Friday, April 11th, and we're hearing on a couple amendments. Senate proposal of amendment, and going to do a little bit more markup and vote on S28. We're going to start with that.
Great. Good afternoon. Jen Carvey from the Office of Legislative Counsel. I will put up the latest draft, which is draft 3.3, and continuing to work on language and provisions and trying to tighten up the existing statutory provisions as well. So draft 3.3 has some new stuff in it and some revised stuff in it, and a lot of what you've already seen. This is S28 is an act relating to access to certain legally protected healthcare services. And section 1 is new because I've put everything in numerical order by title. And this is in Title 1 in under legally protected healthcare activity. That's just where we define terms for purposes of the statutes. And this would add to the existing definition of legally protected healthcare activity to say the protections available to persons who engage in legally protected healthcare activity shall also apply to a person who has previously undertaken one or more acts or omissions while in another U.S. jurisdiction to aid or encourage or attempt to aid or encourage. This is tracking otherwise the language in the definition. Any person in the exercise and enjoyment or attempted exercise and enjoyment of rights to reproductive health care services or gender affirming health care services that would have been protected by this state if they had been undertaken in this state, provided that the acts or omissions were permissible under the laws of the jurisdiction in which the person was located at the time they were undertaking.
Put that into.
Yes. So this is extending the protections that Vermont has in place for providers of legally protected healthcare activity in Vermont to providers who may come to Vermont from another state who have provided these services in another state if they were allowed in that other state. So we're not trying to change other states' rule or laws on things, but just saying if somebody from another state who engaged in what we would consider legally protected healthcare activity in Vermont while they were in that other state and it was allowed in that other state, then if they come here and they're being sought by an entity, by a third state, for example, that Vermont would not cooperate in their extradition or otherwise make them vulnerable.
That makes sense.
Yep. Does that make sense to everybody?
The question is it, I don't know if this is right order of question, but is it because we're going to refer to our statute or we're going to like defer to that state statute that's from?
So this is sort of pulling somebody's lawful in the other state activities under the protections of Vermont law while if they're in Vermont. Am I answering your question? So we're not trying to interpret their law other than to understand that what they did was allowed where they were when they did.
Got it.
When they engaged in that activity.
And that is in this state as well.
Right. All right, then I've renumbered sections accordingly. That's the highlighting for the section numbers, but otherwise no changes. Next change is in this section though. So this is section 4. We've talked about this, but now you're seeing it in context. Section 4 is that the changes to the Consumer Protection Act subchapter that it would now be called healthcare services. And we had looked at revising the definition of healthcare services to track much more closely with the definitions in the legally protected healthcare services statute. So for gender affirming care and reproductive health care, so that it says, so that we're not talking about a behavioral health condition, which is how this existing language can be read, but to instead include that whole list that we have with the addition of dental, which doesn't necessarily apply in the context of gender affirming care or reproductive health care. So healthcare services for the very broad purposes of the Consumer Protection Act and advertising about healthcare services healthcare services means all supplies, care, and services of a medical, dental, behavioral health, mental health, surgical, psychiatric, therapeutic, diagnostic, preventative, rehabilitative, or supportive nature, including medication.
We took out, substance use.
Didn't, because it's not in the definition of the other one, but literally, as I was just reading this, I thought, oh, no, we don't have, so, yes. Care services of a, I think we could add it to the list.
Yeah.
Should we
I
add
mean,
it?
we need to add it. Yes, I don't think it needs to be in the, again, because we took this from the definition of legally protected healthcare services where it wasn't. Because it's not substance use disorder treatment services are not part of either of those. I think sort of no matter how broadly you try to define those services, I think it does make sense to put in here. And we would say substance use disorder treatment. So yes,
We should add that.
yes, remember that in a minute
Maybe
when
not disorder, substance use treatment, are we not?
we call it substance use disorder
Okay.
is what, yes,
That's the
is our
official.
standard terminology there. Okay, then we have another new section. This is again, looking at kind of, things that may be coming at Vermont from outside of Vermont. This is an existing statute enacted in the more judiciary focused Shield law in 2023 on non-cooperation. So it's not a new statute, it's just new in your bill. And a number of the changes are just changing individual, person to individual, because it had person or entity, and person under the broad definition includes entity. So we either need to say individual or entity, or just say person. So we went with individual or entity. So in the existing law, and as amended here, no public agency or employee, appointee, officer or official, or any other now individual acting on behalf of a public agency may knowingly provide any information or expend or use time, money, facilities, property, equipment, personnel, or other resources in furtherance of any interstate, and then this would importantly add, or federal investigation or proceeding seeking to impose civil or criminal liability upon an individual or entity for the provision, seeking or receipt of, or inquiring about legally protected healthcare activity that is legal in the state, or assisting any, and again, that change, individual or entity providing, seeking, receiving, or responding to an inquiry about legally protected healthcare activity that is legal in this state. And then in the existing law, there are exceptions, and we've added to that. So this section shall not apply to any investigation or proceeding, this is existing law, where the conduct subject to potential liability under the investigation or proceeding would be subject to liability under the laws of this state if committed in this state. So basically, you don't get protection under this section if you did something that would subject you to liability if it was done in this state. And then this number 2 is being amended in part to add the federal court, and in part just to improve the language in consultation with one of my judiciary colleagues about Vermont courts. So it does not apply to any order issued by a Vermont state court or a federal court. If a court orders it, people have to comply. That's not optional. Or a public agency or employee, appointee, officer or official, and then we just added language to be consistent with the language at the top here about any other individual acting on behalf of a public agency. So, or any other individual acting on behalf of a public agency who, in the course of normal business, is responding to a warrant or extradition demand on the good faith belief that the warrant or demand is valid in this state. We're not changing that except to align the language. So the main purpose of this section is really just to extend the non-cooperation provisions to include federal actions and investigations, federal investigations or proceedings, but there's some kind of cleanup language in here as well.
And we wouldn't be held any liable for not participating in a federal investigation.
That remains to be seen.
Okay.
This is providing state protection from
Mhm.
to the extent
Okay.
possible. Section 6 is another section that has changed a bit based on some additional work outside the room with various stakeholders. So this is around the disclosure of protected health information prohibited. And we had looked at this the other day, but made a few more changes as well. This is in the language that says, notwithstanding any provision of this requirement in subsection B, that protected health information shall not be disclosed unless it's permitted under HIPAA. Notwithstanding any provision of that, to the contrary, because we're going to say don't provide some information, in order to protect patients and providers who engage in legally protected healthcare activity and except as set forth in subdivision 2, a covered entity or business associate shall not disclose protected health information that is identifiable or susceptible to re-identification and is related to a legally protected healthcare activity. First, to any government entity other than the state of Vermont or its political subdivisions or instrumentalities, if the covered entity or business associate has reason to believe that the information will be used. And we looked at this the other day. The change is only from person to individual, to conduct a criminal, civil, administrative, or professional disciplinary action into any individual for the mere act of seeking, obtaining, providing, or facilitating a legally protected healthcare activity. To impose criminal, civil, or administrative liability or professional disciplinary action on any individual for the mere act of, so the first is conduct an investigation, next is impose disciplinary liability or disciplinary action on any, again, changing from person to individual for the mere act of seeking, obtaining, providing, or facilitating a legally protected healthcare activity, or to identify any, again, change from person to individual for any of the activities described in subdivision 1 or 2. And then we have the exception, notwithstanding any provision of Division 1, a covered entity or business associate may disclose protected health information that is identifiable or susceptible to re-identification and is related to a legally protected healthcare activity if the disclosure meets one or more of the following requirements. And these haven't changed since we looked at them the other day. It's authorized. It's ordered by a court of competent jurisdiction, so court order. But the order must include the court's determination that the information will not be used to impose criminal, civil, or administrative liability or professional disciplinary action on any, again, individual based solely on the fact that they sought, obtained, provided, or facilitated an illegally protected healthcare activity. C is just some clarifying language around the business. It's a business associate designated by the covered entity who is different from their other business associates. So we're trying to clarify that here. The new language, though, is, you haven't seen, is subject to the limitations set forth in that non-cooperation statute we just looked at. The disclosure is required in the ordinary course of business of Vermont's Medicaid program. There are some concerns that if we didn't have some sort of carve out here, that it could jeopardize our Medicaid program. And so this is saying, look, if it's part of the normal course of operating our Medicaid program and the disclosure is required, then the disclosure can be made. But if it's for the purpose of trying to identify somebody to subject them to an investigation or liability, it's not. All right, then we have, I didn't highlight, but section 7 is renumbered, 8 is renumbered, 9 is renumbered. These don't have changes. This was after we talked the other day, Representative McFawn suggested perhaps the term here should be consultation with healthcare providers, because we do, that is a defined term. That was a good call, so I made that change. And I did the same thing in the language. This is around the questionnaire, adaptive questionnaire. The term is not defined in the advanced practice registered nurses subchapter, or even in the chapter on nursing generally. There's no definition of healthcare professional or healthcare provider, but I did change the term at least to be consistent with the language that is in the Board of Medical Practice statute. I think that may be it. That is it. We need to make that change around the substance use
We'll make the substance use disorder change. And any questions for Jim?
Will that make it draft 3.4?
Sure.
Okay.
It can be 4.1 or 3.4, whatever you prefer. I need to clean it up and, I need to take out all the highlighting anyway. Let me just make that addition and I will put the language up so you can see it.
So let's give Jen a few minutes. If there's no other questions on it, I'd like to vote on this. So we'll give her a minute to make the change. Yes, Woody?
Would this bill prevent bounty hunters from coming to Vermont and for somebody that broke our laws elsewhere and that come to Vermont?
Yeah, that's a question from legislative council.
I think this is really more about the state not cooperating, so I mean, it's first of all, it's not gonna stop anybody from coming to Vermont. But I don't believe if there was and I'm getting a little out of my area of expertise, bounty hunters are not really in my healthcare portfolio, but I would imagine it would not stop somebody who was trying to search out a person who another state or the federal government was seeking, but they might still have run into the same obstacles extraditing the person out of the state.
No, just hypothetical,
You never know with these.
I mean, never mind, I'm not gonna.
No, we just never know.
Sorry, version 3.3?
3.4. 3.4. Just making that little change. All right, so let me, a moment, just put this version Word document up. Open to alternative placements. I put it in after mental health because that's where we often have it in other contexts. So it would say services of a medical, dental, behavioral health, mental health, substance use disorder treatment, surgical, psychiatric, therapeutic, diagnostic, preventative, rehabilitative, or supportive nature, including.
Right. I just would like to take a minute. I think we're waiting for somebody to actually come into the room.
I can make a motion, but then we can discuss it.
Oh, sure.
So I move that we take a straw poll to support the amendments to S28. Any discussion?
Are we? So we take a straw poll on this
For the amendments.
for the amendments. I'm never gonna get this. I would second your. Right, so let's take a straw poll. Does, all in favor of accepting these amendments? Okay, 11-0-0.
How did you vote?
Raise my hand.
I didn't see you do it, I'm sorry.
I did, I saw. Yeah. I would entertain a motion. But
I would like to make a motion that we adopt F28 as amended. Version, what are we, 1.4? 3.4.
all right, will the clerk call the roll?
Representative Cheney.
Yes.
Representative Cordes, yes. Representative Critchlow.
Yes.
Representative DeMar.
No.
Representative Goldman.
Yes.
Representative Hogan.
Yes.
Representative Page.
No,
Representative Powers.
No.
Representative Rebecca.
Yes.
Representative McFawn.
Yes.
Representative Black.
Yes.
Motion passes on a vote of 8-3-0.
Thank you, everybody. And the reporter of this will be Representative Rokapko.
And I have an email that I'm sending to you right now, Daisy.
We'll get that off.
Yes, I'm just making, yep, I have to make a clean version, which is what I'm doing now. No. Highlighting.
Is that what sort of editing first? or-
No, because I've been having them edit drafts as I've been going along.
Okay.
Thank you.
Great, thank you, everyone. When Jen is ready, let's move to H80. Okay.
Yeah, I'll pause on this and I'll finish it up. We are done.
This we will just be taking straw poll on. Because we don't actually have possession on it, but it was on notice calendar today.
The changes are pretty minimal, you'll see. So it was done as a strike all for ease of use, but so that's why I am showing the markup from the Senate proposal of amendment. So this is H80, an act relating to the Office of the Healthcare Advocate. And the markup in here shows the changes that the Senate made to what you sent over to them. So no changes in the first part on the health insurance rate review. In the second section, which is the certificate of need process, there had been a request, I think it may have even come here, but didn't make it in, that to strike the language as far as the Office of the Healthcare Advocate and Long-Term Care Ombudsman's roles in participating as interested parties in certificate of need applications, that to strike the ability to ask questions of employees of the board related to the board's review of the certificate of need application. I think the board had suggested this was not appropriate from a party, interested party, someone who'd been granted party status, to be able to ask questions of the board. And I think the Healthcare Advocate's Office, I'll look over to Mike Fisher, but I think they were comfortable with that distinction. And so this language came out.
Do we know if all parties were in agreement with this language? This is.
Both sides, yes.
Okay.
And yes, and it was, this is not a change from existing law, it's a change from the bill, so.
And I'll just say, Mike Fisher, Healthcare Advocate, we agreed with the board that it didn't make sense for us to.
Okay.
I didn't want to speak for him. And so I just renumbered the remaining subdivisions there. The last changes are in the chapter on the Office of Healthcare Advocate, and there are just a couple of changes here that, again, the Healthcare Advocate's Office was involved and, was one of the stakeholders involved in coming up with these. And so I let Mike speak for himself, but I believe their office is comfortable. So the first is in the language you sent over saying that healthcare providers and health insurers shall cooperate with the office by providing relevant records and information when the individual or their guardian or legal representative has authorized the office to act on the individual's behalf. The Agency of Human Services, in particular, as a Medicaid and therefore an insurer for purposes of this, wanted language saying that a provider or insurer may require the written consent of the individual or their guardian or legal representative prior to providing the records or information. So it might be that they need something in writing and just a verbal authorization is not enough. So it's permissive, but it may be required. And then the last change has to do with the duties of state agencies. And so in the bill you sent over, it said, in developing state policy affecting healthcare access and affordability, state agencies shall seek input from the Office of the Healthcare Advocate. There was some concern from state agencies that they would have to can seek input on anything they did that affected healthcare access and affordability. So we've modified this to say it is the intent of the General Assembly that state agencies shall seek input from the Office of the Healthcare Advocate when developing or revising significant matters of state policy affecting healthcare access and affordability in order to ensure that Vermonters' perspectives are heard and considered through the voice of their independent advocate. And that idea of them being an independent voice for Vermonters sort of echoes Section 9601 as amended at the beginning of this. So it seemed like an appropriate reference. And that is it. Those are the only changes. Any questions?
Yes.
Do we have a definition of independent advocate?
We do not, but they're an advocate who is not part of state government. So that's the independence.
No questions? Okay, so I guess we'll just take a straw poll. All in favor of supporting H80 as amended by the Senate? And I think we're 902 now. Wendy, you're gonna wanna write that down.
Okay.
So Wendy will report this on the floor Tuesday. That we concurred with the changes in the Senate proposal of amendment. Right? Oh.
I'm
oh,
watching it.
so- okay.
10-0-9.
I'll be right in at any vote.
Okay.
Maybe I should want to, so it's a little more direct.
All right. Yeah. Is your question, Tucker?
No,
Or
no.
your comment? You sure?
Yeah, I'm sure.
Okay. All right, S27.
Yes, and I just made that same change in it. You'll see.
So I've asked Jen to prepare an amendment to S27, and this is again around, and we've had a lot of conversation about this around the behavioral health and how it was written in there. And I'm proposing that we amend S27, the medical debt, by incorporating almost the exact same language that we just saw in S28. Yes.
So I'll put it up, and I did just add that substance use disorder treatment piece in again. Yeah, so this is just a single instance of amendment from the chair amending the committee's report, which was a strike all on S27 in section 3, which is about prohibiting reporting of medical debt to credit reporting agencies and prohibiting them from maintaining information on medical debt in a patient's or in a consumer's credit report, in the file in their credit report. The issue here is the definition of medical debt derives from the definition from debt related to healthcare services, which has a definition of healthcare services that looked like the one in S28 before we just changed it. So it has the behavioral or mental health disorder. This would use that same definition that we just changed to in S28, and I added substance use disorder treatment while we were talking. So that definition would then become all supplies, care, and services of a medical, dental, behavioral health, mental health, substance use disorder treatment, surgical, psychiatric, therapeutic, diagnostic, preventative, rehabilitative, or supportive nature, including medication. And again, this is a particularly externally focused provision because it's really talking to, for medical debt purposes, it's talking to consumer credit reporting agencies, which are likely not located in Vermont.
Do we need treatment after substance use disorder?
It feels strange to say substance use disorder nature, like care of I mean, I guess it is care of I don't know, we usually refer to substance use disorder treatment, but you're right. Is it repetitive to say?
You just use the one we voted on?
Yeah,
Yeah. But you can reopen if you need.
I think it sounds clumsy without having the treatment.
Whatever you guys think. I mean, I know the intent.
Surgical.
I think it's fine. Reporter.
That's my opinion.
There was a reporter and.
So what do we need to
Actually,
do?
a
Take
process-
straw poll
As
on
a
it?
process question, will I be the one reporting the?
And whose name is on it? Right now it's your name, so yes,
It can be anybody's
it could
name.
be anybody's name.
Would
Yes, the committee
anyone,
doesn't.
would anyone like to join me on this?
Yes, I don't see. I'm fine either way. I'm not.
Okay.
You're just looking for a name up there? You're not asking anything?
No, I'm just asking if
Yes,
anyone, I'm asking if anyone wants to like join me.
I mean, I'd be happy to, but I don't think you need me.
I was gonna say the same thing.
I will just say, for the record, I feel very, very strongly about, and I know that sometimes this can be stigmatizing. And if we were talking about something that was within our own state, that would be one thing. But I just feel very, very strongly that anytime we have a bill where it's outside of our state and it's that it's important to include this because we have to recognize that, you know, the federal government uses this term, other states use this term, and in this particular instance of this bill, we are talking about reporting medical debt on people's credit reports, which is an out-of-state entity. And I don't want to open any possible thing where a credit reporting agency or a provider can say, oh, no, it's okay to put somebody's medical debt on their credit reports because we deem it that it was behavioral health. And so I feel really strongly that we need to keep that in there. And I will be the only one, I guess, proposing this amendment. All by
I'll
myself.
have my name up there.
Oh, you can, yeah, that's what I'm asking. Does
Okay.
anyone else want to put their name on it?
just
I would be happy
Yeah,
to.
yeah, just,
were
did anyone
planning
else
it
want to
for-
put their
yeah.
name on it with me?
Absolutely.
Yeah, does anyone not want to have their name? Can it be a committee?
Their name on it.
Just have it be a committee bill.
Well, it can't be, you don't have the bill anymore.
Okay.
So you all have to be individually listed, which is fine, but
Yeah,
need to know.
so let's add everyone's name and I will check in with maybe Brian can let us know if he'd like to be on it, and I will check in with Leslie.
okay. So everyone wants to be or is comfortable being on it.
Yes.
Okay.
Yes.
You gotta check in with Brian.
Oh, and here's one.
I'm fine with my name being on it.
Okay, thank you.
So just send me the Zoom link, and then I'll just come in to vote.
Yeah, that's it. Jack in the box.
It's a check.
Oh, actually, we should have just stayed in here. Does everyone support this amendment on a show of hands?
Since your names are all on it.
My name, long week, Jen.
Actually, I believe that's happened this week. So it would not be unusual.
Yes.
Speaking of Captain Obvious.
Clarify. Okay, are we done?
Yep.
Oh, we are done. We have a big day on the floor. I think we were the entire notice calendar today.
I think we were.
So medical debt has gone through both Ways and Means and appropriations. My bad. Not medical debt went through appropriations. Woody will be reporting on the floor on Tuesday. I'll present the amendment. Yep,
At the very end,
yeah.
after appropriations.
Yes, yeah, and then Wendy will be reporting her first
Amendment.
Senate proposal of amendment. And then Daisy will probably be on Tuesday,
The notice
Jen-
for Wednesday.
Careful.
Wednesday. There's,
They might not let
I
you
keep
cross
getting
the
it wrong,
border.
there is absolutely
Whatever you ask for.
nothing that would send this
Just because you
to,
play on their team, that don't mean.
No.
it doesn't affect
Possible
Medicaid.
somebody could make a motion to
Are we
send it to.
offline?
No, I'm just,
No, I was just.
Thought we were.
we can go
Oh, are we
offline.
not?